welcome to another one of our video employment law and HR updates. This time we're going to be talking about COVID vaccinations and specifically in relation to whether employers can compel their employees to have these vaccinations or not. The reason for this update is because this is something that has become much more of an issue lately, particularly as a result of the reporting over the last few days of Pimlico Plumbers, and the Pimlico Plumbers owner Charlie Mullins, who's come out and said that employees will not be allowed to come back to work until they've had the vaccine, coming out with a quip of no jab, no job. This has been unsurprisingly heavily criticised by some, and specifically by the vaccine minister Nadhim Zawahi, who has criticised this approach by saying that it would be discriminatory to take such an approach to workers, and that vaccines should not be compulsory, rather they should be voluntary, and that they're going to be made available by the NHS through the quite impressive rollout that obviously is happening at the moment. But that nobody should be dismissed for not having the vaccine. So what are the legalities of this? And is the vaccines minister right to say that it would be discriminatory of employers to require their employees and their workers to have the vaccine? So let's have a look at what the law actually says, and obviously in particular what the Equality Act says about it, as that's where all the discrimination legislation is. So one of the things that perhaps hasn't come across perfectly as a result of the reporting of this is that Pimlico Plumbers, of course, do have quite an interesting model on which they base their model of their work based upon workers and self-employment, rather than necessarily the traditional employment model. And in fact, they had a case that went to the Supreme Court about 12 or 18 months ago. And so this has been slightly skewed by this. But having said all of that, of course, even as workers, so whether you are an employee or a worker, what is referred to in law as a Lim B worker, even if you are only a Lim B worker, you don't have full employment rights, you still have the right not to be discriminated against. Discrimination law still applies. And so let's have a look at the various scenarios within which employers might be having a look at compelling employees to all their workers to have the vaccine. So first of all, we have got the point of whether at the recruitment stage an employer could require the employee to have the vaccine, and that would form part of the offer of employment. So in the same way that an offer of employment might require an employee to provide references, to provide satisfactory employment references, or a pre-employment medical, or of course the documentation to show that you've got the right to work in the UK, could the employer therefore also put in a similar requirement in the employment contract, which ensures that they will only be offered the job, or that the offer will only become binding upon them showing evidence of the fact that they have taken the new vaccine? Would there be a discrimination point on this? Well, yes, there could be. And the first and most significant area of discrimination is going to be disability legislation, and in particular under sections 15 and 20 of the Equality Act. Now, what sections 15 and 20 provide for is that somebody cannot be discriminated for a reason arising out of their disability, or alternatively that a reasonable adjustment should be made because of their disability. So what disability could there be in these sorts of instances? Well, as I said, the vaccine might not be suitable for everyone. For example, if an individual has a suppressed immune system, they might not be able to have it because of this. And therefore, if they can't have the vaccine because of the suppressed immune system, and that suppressed immune system is a significant enough condition for it to qualify as a disability, then the requirement to have that vaccine, and the failure therefore to follow through with the job offer, is going to potentially be an act of disability discrimination. And so therefore employers are going to have to be very wary of taking a broad brush approach to to an issue such as the vaccine, because there are going to be individuals who are going to be in different situations, and therefore different. The employer is going to have to approach things in a different way. We've also got the issue of religion and belief here, and so if somebody could, for example, or at least one of the issues in relation to vaccines generally has frequently been that they contain animal products, and so therefore, because they contain animal products, people who have either a religion which prevents them from consuming such animal products, or alternatively perhaps they might be vegan and that therefore, or vegetarian, and therefore they also have that belief system which then prevents them from ingesting in some form a vaccine which has gelatin, that would then cause a discriminatory act in connection with religion and belief. But this doesn't apply to the COVID-19 vaccine, because the Pfizer, the Moderna, and also the Oxford AstraZeneca vaccines do not contain any animal products whatsoever. And so therefore, the issue that commonly arises in relation to both the nasal flu vaccine, one of the MMR vaccines, and also the chickenpox vaccines doesn't apply in this instance. Also, the British Islamic Medical Association have also recommended that people have the COVID-19 vaccine, and they've stressed that there is also a negligible amount of alcohol in any of the vaccines, no more than, say, for example, in bread, and so therefore that also shouldn't prevent anyone from that faith which prevents them from consuming alcohol to have the vaccine. But then we move on to and I appreciate that I'm using a very broad and sweeping term here by using the term anti-vaxxers. But what about people who positively believe that having a vaccine is wrong, that taking a vaccine is wrong? And so what we need to do with this group of individuals is that we need to have a look at the case law that was established some 10 years ago by the case of Granger and Nicholson. And what the Granger and Nicholson case did was it set out 5 specific criteria which must be met in order to show that you are protected by the religion and belief protected characteristic under the Equality Act. And those 5 points are, first of all, number 1, that the belief must be genuinely held. Secondly, that it must be a belief and not a viewpoint or opinion. Thirdly, it must be a belief which is weighty and substantial. Fourthly, it must attain a level of cogency and seriousness and cohesion and importance. So it can't just be a whim. And then finally, and this is probably the most important one that tribunals might have to grapple with when they're dealing with these issues, is that it must be worthy of respect in a democratic society. That is to say that it must not be incompatible with human dignity and not conflict with the fundamental rights of others. Now, in saying that I think that's an important point, I'm not saying that my viewpoint is that anybody that considers not taking a vaccine necessarily to be not worthy of respect in a democratic society. But what I am saying, of course, is that there is a particular viewpoint here that people taking such a view might be in conflict with the general view of society, and therefore call into question whether in fact this 5th point, this 5th criteria could actually be met by, and I apologise again for the sweeping generalisation, by anti-vaxxers. Now, it's going to be very interesting to see what approach the tribunal might, or tribunals might take to this. I think that it's going to be an argument which is going to have to play out, and obviously as a result of that, we just simply don't know. We cannot provide you necessarily with a guarantee that anti-vaxxers are going to not have protection under religion and belief discrimination, and in fact there is a real risk that in fact they might do. But again, this is going to vary on a case-by-case basis. So making a very sweeping generalization with such a sweeping term such as anti-vaxxers isn't particularly helpful of me, and I completely get that. But I want to make the point that actually one person who doesn't believe in having vaccines might be protected, whereas another person who doesn't believe in having vaccines might not be protected, because it all depends upon the way that they live their life and the extent to which their belief system actually affects the way that they live their life. And there have been various cases, not necessarily dealing with the anti-vaccination point, but there have been various cases in relation to, say, for example, political beliefs, and whether just simply supporting the Labour Party isn't sufficient enough to constitute religion and belief. But if you believe in socialism, which is going that much further and does affect the way that somebody lives their life, does provide that protection. So it is really going to vary on a case-by-case basis. So it's not something that we can absolutely say one way or the other with a sweeping statement such as anti-vaxxers, whether people would be protected or not. So it's really a very difficult area, is really what I'm saying. So there are discrimination risks. The Vaccines Minister was quite right to indicate that there would be discrimination risk by making such a wide position as Pimlico Plumbers, or should I say such a line in the sand as Pimlico Plumbers were originally saying that they were going to make. I have to point out also that Charlie Mullins of Pimlico Plumbers has sort of stepped back a little bit from the original comments that he has made, and has said that nobody is going to be disciplined or dismissed for not having the vaccine. So I suspect that some of the points that we're making here have also come to the fore in the position that Pimlico Plumbers are now taking. So that's really dealing with the discrimination risk. But what about the contract of employment? Because of course, one of the things that we're looking at here is whether, if in fact somebody isn't protected by discrimination, so they don't have an underlying disability, and there is no religion or belief issue here, can we, for those people, still make a change to their contract of employment that would therefore compel them to have the vaccine? Now, first of all, just dealing with the pre-recruitment stage, there is the possibility that therefore, if there isn't any discrimination issue, that you could include the requirement to show evidence that you've had the vaccine as part of your part of the requirement to start employment. So there's nothing really necessarily standing in your way of doing that, if that's the approach that you wanted to take. But in terms of existing employees, there of course we have a bit more of an issue, because we would have to amend the contract of employment in order to actually then contractually compel the employee to have the vaccine. I'll get on to what we would do if they didn't have the vaccine, having the contractual right, in a moment. But let's just have a look at amending the contract of employment in the first place. Now, first of all, to change the contract of employment, we're left with a number of stark options. I mean, first of all, either they just simply agree to the change. Now, of course, if they agree to the change, then that's likely to be because they completely accept and in fact want to have the vaccine, and so therefore they're not going to be a problem anyway. So we don't really need to change the contract of employment of individuals who are going to have the vaccine, because we're not going to have to compel them in any event. So therefore we've got to decide how we would force a change of contract on individuals that don't want to sign any amendment of this nature. And really we've got two fairly stark options. First of all is to dismiss and re-engage. And if we are doing that for 20 or more people, we would also have to undertake a collective consultation process of either 30 days or 45 days if it's more than 99 employees that we're proposing to dismiss and re-engage. So there would be a significant amount of upfront work in relation to consultation that we would need to do with elected employee representatives. The second option is to simply impose the change. Both of those carry significant risks, because with the dismissal and re-engagement, we are of course dismissing and re-engaging. So therefore we've got to show that the dismissal is fair in the first place. So therefore it means that we're dismissing for the failure of that individual to sign up to a contract which would compel them to have a vaccine, essentially a medical procedure. So it's going to be rather difficult for us to show without some very persuasive information about why we need to compel them to have the vaccine. It's going to be very difficult for us to be able to show that is a reasonable dismissal, is a fair reason for dismissal. And secondly, if we're imposing the change, then that's going to leave us open to constructive unfair dismissal risks. So people either resigning at that point that the change is made, or alternatively they get a second bite of the cherry because they can then decide to resign once that term bites. So once they are then compelled to have that vaccination under the new imposed contract of employment, they could then choose to resign at that point. And again, it's going to be very difficult for us to be able to show that it's a reasonable and fair dismissal. So that's a very risky approach. And even if we do get those changes to the contracts, then what does that mean? And are we actually going to be able to discipline and dismiss employees as a result of not having the vaccine? Now, this is then when ACAS have helpfully provided a bit of guidance on this point. But I mean, first of all, just taking the view of what, or trying to put ourselves in the position of what a tribunal might think. I think that a tribunal is going to be reluctant, incredibly reluctant in fact, to effectively permit employers to force an employee to undergo a medical procedure to keep their job. So their starting point is going to be sympathetic to the employee. Also, the ACAS guidance on this point states that employers, and I will just make this a little bit bigger so that you can see it properly, that employers should support staff in getting the coronavirus COVID-19 vaccine, but they cannot force staff to be vaccinated. But they go on in this guidance to actually suggest that in some situations, a refusal to be vaccinated could result in a disciplinary process. They don't talk about dismissal, but they do talk about a disciplinary process. But this would still turn on whether in fact it is necessary for somebody to have that vaccination, to have the COVID vaccination in order to do their job. And the example that they give in that respect is if staff need to travel to other countries to undertake their work, and for that travelling purpose they therefore need to have the vaccination. And so in that instance, and that's quite a narrow instance, that because they need it to do their job, and because that is a requirement, it is a requirement to have the vaccine in order to undertake that travel, then there could be disciplinary action. But even if that is going to be the case, then the guidance is indicating that employers should agree with their workplace representatives, their consultative forum, trade union, that this is the approach that is going to be taken, that there should be an agreement in writing, and that should be perhaps reflected also in a workplace policy. So what other options do employers have? So if disciplining and dismissal is in most instances off the table, what else can we do? Well, one of the possibilities, or one of the other possibilities that has been talked about, is whether in fact the employer could decide on health and safety grounds not to permit individuals who have not been vaccinated to attend the workplace. But again, we're going to hit another set of issues here, because, well, first of all, the most obvious issue is that the rollout of the vaccination program by the NHS is, for obvious reasons, prioritising at-risk groups, which means that younger employees are going to be left until right at the very end. So if you were to take a decision, say for example in March, that only vaccinated employees could come to work, then clearly there are going to be lots of employees that can't come to work. So when would you be implementing this as a program? If you implement it after the complete rollout of the vaccination, then yes, in theory, we are not going to have to deal with the age discrimination issue, because everyone will have been, all of the groups of society will have been covered by that point. We've still also got the disability discrimination issue that we spoke about before, and also the religion and belief issue that we spoke about before. So those discrimination issues that provided the reasons as to why somebody wouldn't be having the vaccine would also be alive, and if they were prevented from coming to work because of those issues, then that would give rise to a discrimination claim. We've also got the potential for breach of contract and unlawful deduction from wages claims if the contract hasn't been amended appropriately. I say appropriately, if the contract hasn't been amended to require employees to have the vaccinations in order to be permitted to attend work. And of course we've got all of the risks connected with forcing those changes in the contracts that I've just spoken about. So all in all, that is giving us some really significant hurdles if you're wanting to take disciplinary action up to and including dismissal in relation to employees that haven't had the vaccine. But what about people with less than 2 years service? Because of course people with less than 2 years service do not have the right to bring an unfair dismissal claim. So unless they are going to be protected by the disability issue, disability discrimination issue, or perhaps religion and belief, or perhaps age discrimination, as we've just spoken about, then they're not going to be able to bring an unfair dismissal claim unless that unfair dismissal claim is protected by one of the automatic reasons for unfair dismissal. And there's a possibility that that could give rise to a automatic reason of dismissal for health and safety, perhaps, given that they might believe that it's affecting their own health and safety if they were to have the vaccine. So even then, again, we're coming up against risks and hurdles. And of course, in an automatic unfair dismissal claim, there is no no normal limit in compensation and the compensatory award that there would be in relation to other unfair dismissal claims. But with that exception, then yes, you could technically dismiss anyone with less than 2 years service who refuses to have the vaccine, albeit that there might not actually be the contractual requirement to have the vaccine. It wouldn't be a gross misconduct dismissal unless you've changed the contract of employment, and so therefore you would be having to pay notice if you were dismissing. But this is going to give rise to all sorts of employer relations issues within the workforce if you're dismissing people with less than 2 years service. And so it would seem to me to be a very inappropriate route to take from an employee engagement point of view, and also what are you going to gain from doing it? Because you're still going to be left with the vast majority of your employees, I would imagine, who have got more than 2 years service, and those that haven't been vaccinated still being able to continue to come to work. So in terms of a risk profile for the organisation, a health and safety risk profile for the organisation doesn't really change anything anyway. So that's not something that I think is a particularly good idea, although of course you're perfectly entitled to make your own judgment calls on this. So all in all, there are some real hurdles, real issues in relation to employees trying to enforce or compel employees to have the COVID vaccine. Our guidance really does fall in line with the ACAS guidance. I mean, and you won't be surprised to hear that, but that's for all of the reasons that I've set out here, which is the fact that compelling employees to have the vaccine comes up against so many discrimination hurdles. It comes up against unfair dismissal hurdles. And so unless the government actually changes the approach that it takes and makes it mandatory for people to have the vaccine, then employers aren't going to be able to make it mandatory. Although, all in all, I think this is going to sort itself out, because of course, what could well happen within society itself is that places such as cinemas and theatres, perhaps even restaurants, but certainly air travel and travelling abroad and holidays, companies that are operating such activities may well make it a requirement for individuals to show that they've had the vaccine in order to be able to attend such events, whether it be festivals, music concerts and what have you. And so if there is then a requirement to have the vaccine in order to be allowed to attend such events, people are going to end up having the vaccine, unless of course there are very good reasons as to why they can't. And so largely speaking, I would expect this to be a problem which resolves itself, and that it's not it won't be necessary for employers to take a heavy-handed approach with threats of dismissal or disciplinary action if people don't get the COVID vaccination. So I hope you've all found that perhaps quite useful in relation to what approach you're going to be taking in relation to the COVID vaccine in the workplace. So really it's encourage, provide information to your employees, ensure that if anybody's having difficulty getting hold of the vaccine, then you can give them contact numbers and some advice about where they should go in order to resolve that problem for them. But anyway, hope that's been helpful. Obviously keep an eye out for our other videos that we'll post up on a regular basis, and see you soon. Bye.